Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 247 of the NCDWI Guy podcast. On today's episode, we are talking about DWI trial tactics using the Bible for DWI Defense, the NHTSA Participant Manual to the 24-hour SFST training that officers go through in your cross-examination to fullest effect. This episode is taken from a recent recording of a webinar that I did for the Mecklenburg County Bar Association. They graciously allowed me to repost this on my podcast. It was a great opportunity to talk about the NHTSA training, and I hope you enjoy today's episode. Yeah, thank you so much. I'm really excited to be able to present on this topic. It's really one of my favorite topics to talk about. So again, my name is Jake Minnick. I work with Minnick Law. We have offices throughout North Carolina. We focus on criminal defense, and I would say our biggest place of practice and certainly trials is DWI cases. And so walking through the SFST participant course and manual that NHTSA teaches is really, to me, like the foundation of DWI defense. So we are going to kick this thing off with a little bit of gold, a huge Seinfeld fan. So gonna start it strong. And here is the number one takeaway that I have for you if you are on this call, and that is you need to take a class from somebody else, and that class is the full NHTSA training. So as much as we may get out of an hour, we are literally not going to scratch the surface of what is contained in the NHTSA manual. And to me, the actual full 24-hour course is where the rubber meets the road on DWI defense. So number one takeaway for today is take one of these trainings. Actually, one of them is going on currently just down the road in Gastonia with Marco Aureliano. He is kind of new in the expert defense realm. Marco is amazing. I've had him on my podcast, and Lance in our Gastonia office is now using him as an expert witness on a couple of our cases, and just a great guy, really knowledgeable. Doug Scott has been doing it for a long time. He is getting ready to do the NHTSA class in Raleigh at the end of the month. And then Anthony Palacios, who is based out of Alpharetta near Atlanta, Georgia, does the courses pretty much every quarter. So he's got the most kind of frequent course offerings when it comes to the 24-hour course. But to me, this is the Bible of DWI defense. The NHTSA manual becomes the reference point for cross-examination. I do not think that you can conduct an effective cross-examination of an officer in a DWI case without having taken the class and without knowledge of the manual. You're going to notice I'm looking over to the side a lot. I've got my presenter view over here, so my notes are over this way, so I'm not staring off into space as we're going through this. But this is the first training that anybody at our office goes through when they come in for DWI background is the NHTSA class. And what the NHTSA manual allows you to do, in my opinion, is communicate to those in the courtroom your knowledge of a DWI case. So you can communicate that to the judge, and after repeat DWI trials, I think, or any type of trial, judges start to see who is really got the meat and potatoes down of DWI defense or whatever type of cases that you're routinely trying. The prosecutor, you're communicating to the prosecutor that if you're going to go to war on a case, it's going to be with full force, the officer and your client. Now, and it's important to showcase to your client that you have knowledge in this area because you want them to be happy with your representation, win or lose. And I have had plenty of clients after losing a DWI. We've walked out of the courtroom and they said, I can't believe we lost that. You had such a wonderful cross-examination. They've been some of the happiest clients in individual situations when you've just really gone to war in the courtroom. So why would you want to communicate your knowledge of DWI to the officer? Well, when I was growing up, my dad had boxed briefly at West Point. He was big into boxing, and so he went to a boxing gym growing up in Waynesville. It was right down the road. And George, who was the guy that ran the gym, basically said, you want to make the person on the other side, the person you're fighting, a yes man. And what did George mean by that? He meant you want to have them be hitting them in the head to where their head is just rocking back and forth, right? So you want to make them a yes man. So the reason that you want to communicate your knowledge to the officer is you want to make the officer a yes man. The earlier on that you communicate your understanding of the training that the officer has gone through and that you know it better than they do, you can ask any question about the manual and they assume that you know what you're talking about. So again, you obviously don't want to make up stuff that's not in the manual, that's unethical, but you want to be able to ask questions to where they are geared towards that yes response because you've communicated that you know what you are talking about. So basically the participant manual, and we are going through the February 2023 participant manual. This is the newest version. I included it in the materials. It's on NHTSA's website. Every time there's an update on NHTSA's website, they have the SFST instructor manual, the refresher course, the participant manual, A-RIDE. All of the manuals are updated on their website. You can also get older copies of the manuals as well. But the NHTSA class is a 24-hour course. It's divided into 15 sessions. It includes 2 sessions where officers apply the skills that they are learning to subjects that have been dosed with alcohol, or including some potential people that didn't have any alcohol, to make sure that they really are understanding the difference between an impaired and non-impaired person, but some people that have been dosed with alcohol. And in addition to other overview items, it includes job performance objectives. And so here are the objectives that are laid out in session 1 on page 7 of the 2023 manual. Recognize and interpret evidence of DWI violations, administer and interpret SFSTs, describe evidence clearly in written reports and verbal testimony, and ensure video and/or audio evidence, if available, is consistent with other evidence. And it's a little bit of a strange way to word that, because I don't know how it wouldn't be consistent with other evidence unless the report is not consistent with the audio or video. But again, I think just the emphasis that video and audio is important in this day and age is really critical and something to point out. So session 1 is the introduction and overview. And one of the important things that is taught in this session is the importance of the officer reading the manual. So the participant manual is a reference document for this training. This comes from session 1, page 9. On that same page, the officer is instructed to read each session prior to class. So when you walk into court and you've got a officer that is testifying about field sobriety testing, you need to have an official looking copy of the manual. When you use it in court, you want to have tabs, you want to have it marked up so that you can show what a participant manual looks like to those in the courtroom. It's also a good idea to have potentially multiple editions of the manual, because that way, if an officer says, well, I was trained before 2023, so I don't know what that manual says, you can go back to an older referenced manual. But one of the first questions you should ask in cross-examination when you're using the NHTSA manual as an outline is, Officer Smith, while you completed your 24-hour NHTSA training, you read the NHTSA manual, correct? If yes, they're locked in, right? Like they're now responsible for everything in that manual, whether they remember it or not. You were trained this way. You said you read the manual. Here's what the manual says. Does that, refresh your memory of what you were trained on? If they say yes, they're locked in. If they say no, then they're not following their training. They're not taking it seriously. And you can point to session 1 of the manual that says read each session prior to class. Were you not trained to read each session prior to class? Also in this session is a glossary of terms, and it is very much worth the read. This is session 1, page 12 of the 2023 manual. Similar to the chapter 20 definition section that is in North Carolina General Statute 20-4.01, the definition of terms, there is some great language in that definition section related to traffic charges, DWI cases that comes from that definition section. Similarly, in the NHTSA manual and the glossary of terms, there is some really key information laid out there. So one of the terms that's defined is standardized field sobriety tests. So here's what it says as the standardized field sobriety test. There are 3 NHTSA-approved SFSTs, namely horizontal gaze nystagmus, walk and turn, and one-leg stand. Based on a series of controlled laboratory and field studies, scientifically validated clues of impairment have been identified for each of these 3 tests. They are the only NHTSA-approved standardized field sobriety tests for which validated clues have been identified for DWI investigations. When you have an officer that is using something other than the 3 standardized field sobriety tests, this definition from the glossary of terms is extremely helpful in terms of why it's important for the test to be standardized and why there are only these 3 tests which have been validated for clues of impairment. Another definition in that glossary of terms section is validated. Validated is defined as a documented act of demonstrating that a procedure, process, and/or activity will consistently lead to accurate and reliable results. So if you combine those 2 definitions of standardized field sobriety test and validated, it indicates to the judge, to the jury, why it is important that a test be standardized and what does it mean for there to be a validated clue. So the next section in the manual is session 2, detection and general deterrence. The science in this section is very basic and I would say outdated. It deals with the science of impairment, how alcohol is processed through the body, but this also spends significant time on the deterrent effect of DWI arrests. Again, it goes over the physiology of alcohol. How does this impact the central nervous system? What does absorption of alcohol look like? How is alcohol eliminated? When does somebody hit peak alcohol? The one thing that I would point to that can be helpful if you have a retrograde case, I have not had in a number of years now, the state push a case based on retrograde. I know other attorneys at our firm in different areas of the state, that is still something that is routinely pushed, but I have not had that experience as of late. But one of the things that's helpful in the manual is it indicates the elimination rate of alcohol is 0.015. Now, if you compare that with the 0.0165 rate that's used by state witnesses, expert witnesses, Paul Glover used to testify as to this, whoever the state is calling on your case, this is the number that's routinely used in North Carolina. And so what does that mean? Well, it means that they can get to a higher peak alcohol concentration working backwards from retrograde under the North Carolina state system than would be used if you use the number from the NHTSA manual. And, if they're working backwards through retrograde, typically that means that they're trying to get your client just at above the legal limit. Normally retrograde cases, it's charged as a 0.05, a 0.06, and they're trying to get your client up to 0.08, 0.09, 0.10. And so this kind of minuscule difference may make a difference. But again, the physiology section, which is included in this particular session, the science of alcohol, is very much outdated. It has not been updated in the manuals that I can see in any significant way. I think the first manual that I got when I went through the training was a 2008 manual. And it really hasn't changed in any meaningful way since then. And before that, I don't know kind of how far back there has been any kind of major difference in terms of the science of how alcohol moves through somebody's system. But just to give one example of how outdated some of this information is, it's one of the sections basically says that a can of beer, a glass of wine, and a shot of whiskey are all the same based on a 12-ounce beer at 5% alcohol, a 5-ounce glass of wine at 12%, and a shot of whiskey at 40%. And again, I just think that, obviously, if you know what the alcohol concentration is, maybe you can compare that a little bit, but just basically saying beer, a glass of beer, 5-ounce glass of wine, shot of whiskey are the same without kind of knowing what the proof is of each individual alcohol being chosen is just, again, pretty basic. And it's not meant to make the officer expert in the science, but just be an overview on that. The legal environment is the next session that officers are trained on. And this one is important. This is one worth writing down. If you have a case, particularly in Superior Court, I've argued this in District Court, but if you have a case in Superior Court where the alcohol concentration is greater than 0.08, and you are arguing to the jury that basically the signs and clues and indicators of impairment that are lacking in your client's situation should overcome the presumption of impairment. You're using maybe a Neyron and Simmons argument, asking for a specific jury instruction about the presumptive effect to be given to the 0.08 or greater alcohol concentration that has come into evidence. Then if you've gotten the manual put into evidence, or if you've gotten this section of the manual put into evidence, this could be very helpful in closing. So basically, in session 3 on page 9, you basically get Neyron Simmons from the officer's own training. So this is a direct quote from session 3, page 9. The fact finder, court or jury, may accept the legal presumption and conclude the driver was or was not impaired on the basis of the chemical test alone. However, other evidence such as testimony about the defendant's driving, odor of alcohol, or appearance, behavior, movements, speech, etc., may be sufficient to overcome the presumptive weight of the chemical test. That effectively is like a Neyron Simmons instruction, but it comes directly from the officer's own training. So in terms of arguing that a specific instruction should be given when you're having your back and forth with the judge over what the jury instruction should be, but also in your closing argument, this can be very helpful in terms of persuading the jury to ignore the 0.08 based on the other indicators of sobriety or lack of indicators of impairment from the officer's field sobriety test, personal contact, whatever it might be. At this same location in the manual, there is an example that is given. So this is example 1 on page 10 of session 3. So this is the example. It is possible for a person whose BAC at the time of arrest is above the per se or presumptive legal limit to be acquitted of DWI. It is also possible for a person whose BAC at the time is below the per se or presumptive level to be convicted of DWI. Consider the following examples. Example 1, a driver is arrested for DWI. A chemical test administered to the driver shows a BAC of 0.13. At the subsequent trial, the chemical test evidence is introduced. However, the arresting officer's testimony about the defendant's driving, appearance, and behavior was confusing and unclear. Therefore, the state was unable to prove all the elements of the crime beyond a reasonable doubt. So again, I don't know what leeway you might have in terms of getting that specific example in, if it's helpful in your particular case. But again, I think the point is that officers are trained, and my cross-examination questions would be framed when I've used this in the past around you are trained that 0.08 does not require a conviction. Not that's the law, but that was your training. From day one in field sobriety testing, you've been trained that the end-all be-all is not the number that comes into evidence. Here's part of the session. Again, you indicated that you read this. This was part of your original training. So again, this legal environment can be very helpful if you've got a case where you are arguing that the number coming into evidence above the legal limit should be ignored in light of all of the other evidence of lack of impairment. Session 4 is the next session in the manual, and that is overview of detection, note-taking, and testimony. And again, we're running through this at pretty fast pace. Again, there is a ton of meat in each of these sessions. In addition to taking the class, one of the real value points following taking an NHTSA 24-hour course or during it is to read all of the sessions within the class and mark up that manual, because there's just tons of little nuggets in each session. Again, not just in the sessions that deal with standardized field sobriety testing. Session 5, 6, 7, and 8 are kind of the big ones when it comes to the cross-examination framework of the officer's investigation, personal contact, vehicle in motion, standardized field sobriety testing. We'll get there briefly in just a moment. But all of these sessions have really valuable information in them. So in this session, it goes over the 3 phases of DWI detection. So basically the basic framework for a DWI investigation. And then it discusses the decision at the end of each phase. So this is on session 4, page 5. So phase 1, the decision that needs to get made at the end of phase 1 is, should I stop the vehicle? The decision that needs to get made at the end of phase 2 is, should the driver exit the vehicle? And the decision at the end of phase 3, is there PC to arrest the suspect for driving while impaired? So possible outcome as to each of these decisions is also laid out. Yes, do it now. Wait, look for additional evidence, or no. So the question that gets asked at the end of each phase 1, 2, 3, there's an answer that could be yes, no, or wait. And I think it's the wait category that is kind of the nugget to take away from this particular session. So phase 1, don't stop the vehicle yet, keep following and observing it a bit longer is what you're supposed to do if the answer is wait. So I haven't seen any particular traffic violation. Should I stop the vehicle? The answer could be no, because obviously you haven't seen the traffic violation, or it could be wait and look for additional evidence. Phase three, if the answer is wait, then that means don't arrest the driver yet. Administer another field sobriety test before deciding. So I think why this is important and why this wait category is so helpful is that what you can say anytime that there is a case that you have that's going forward on reasonable suspicion is, based on what the officer saw, he had the opportunity, and this may not apply in every single reasonable suspicion case, but you can say, based on what the officer saw in terms of traffic violations, driving, the best thing that the officer should have done is follow his training and waited, continued to follow the vehicle and look for additional signs and indicators of impairment. That was an option. In your honor, finding that there was not reasonable suspicion, it's basically the same as saying you should have at least waited a little bit longer and looked for additional evidence of bad driving before initiating a traffic stop. Same thing when it comes to PC to arrest. If you have a client that gets pulled over, they do the horizontal gaze nystagmus testing, and that's it. They do let's say they get 6 out of 6 clues on the HGN, but everything else, your client is talking, walking, fine. There's no difficulty with vehicle exit. There's no weird answers to questions. One of the ways for arguing no PC is to say the officer had the opportunity to administer additional field sobriety testing, could have waited and done additional field sobriety tests before actually making the arrest. And in fact, they're supposed to. They're supposed to do the 3 field sobriety tests as a battery of tests. So you push that anyways. You push the fact that they ignore their training by not doing the full battery of tests. But it's also to point out that the officer is jumping the gun. They have additional things that they can utilize in their tool bag to determine if somebody is impaired, to determine whether they're stopping an impaired driver, whether they should get a person out of the vehicle, whether or not they should arrest somebody for driving while impaired. And so one of the options that they have is to wait. And so again, I think that this can be a really powerful way of framing it to the court if it appears that the officer is going off of limited information. Also within session 4, the importance of field notes is pointed out, and this actually comes up several times within the manual, the importance of field notes. I mean, you'll probably find something on field notes and the importance of accurate note taking in almost every session of the 15. But here in session 4, page 13, it says reports must be clearly written and events accurately described if the reports are to have evidentiary value. Similarly, since evidence of a DWI violation is short-lived, you need a system and tools for recording field notes at scenes of DWI investigations. Remember, you must document those actions which gave you reasonable suspicion or probable cause to justify further investigation of a suspected DWI incident. It is your responsibility to compile complete, accurate field notes, and to prepare a complete, accurate, and detailed report. So the importance of both field notes. So field notes, as is referenced by the manual, is the notes that are getting taken on scene. And then the report is what is getting written later by the officer at the jail or the following day, whatever time frame after the investigation is done. But the field notes are what getting recorded in real time. And so I think one of the kind of important pieces here is that there are a lot of officers that have a report, whether that's the DWIR form or whether that is a written or typed narrative, but that's something that is getting completed after the arrest has occurred back at the jail or once they get back to the police station. But Session 4 talks about the importance of the field notes. So what is happening in real time as you're doing field sobriety tests. So again, this is a potential question then for an officer that doesn't have any field notes, but later is indicating at the jail, 2 hours after the event, the specific clues that they remember seeing on standardized field sobriety tests. It doesn't seem entirely plausible that you're going to remember which specific steps that somebody missed on the walk and turn test 2 hours later at the jail. They missed step 3, 5 on the way down and 7 and 9 on the way back, right? Like that doesn't make sense that somebody's going to have that photographic memory. So the importance of field notes. So again, if there are no field notes, pointing out the fact that the officer is not following their training as it is related to field notes. So again, simple way of putting this into cross-examination. Isn't it true, Officer Jones, that you were trained to take complete, accurate, and detailed notes? Did you do that in this case? Again, if they did, maybe you get to compare that with what is ultimately in the report that is done later, and maybe there's inconsistencies, but a lot more times than not, the officer's not going to have done field notes, at least on the cases that I have had. I would say it's definitely higher than 50% where officers do not have any field notes, even if they have an ultimate report on their case. Session 5, this is phase 1, the vehicle in motion. So we're kind of getting to the real substance of the manuals. And I would say that sessions 5, 6, 7, and 8, when you take a 24-hour NHTSA class, that is where the bulk of time is typically spent, is on sessions 5, 6, 7, and 8, because again, that's really, here's how the actual investigation is supposed to occur. So we are not going to get too deep into sessions 5, 6, 7, and 8. You really need a 24-hour class to get into the real heart of these kind of very lengthy and detailed sessions. But this is really where the value of those 24-hour NHTSA classes comes from. So in some highlights from sessions 5, 6, 7, and 8, in session 5, it explains the 24 driving clues of impairment. These clues, it indicates, fall into 4 categories: problems maintaining lane, speed and braking problems, vigilance problems, judgment problems. It identifies the post-stop clues in the visual detection of DWI motorists, because those are no longer in the substantive manual section. So I'm going to pull those up over here on the right. This is now only in the appendix of session 5. It used to be at the very end in the substantive portion of phase 1. Now you'll only find this in the appendix under the visual detection of DWI motorists. And this can be important because when you're basically pointing out that these clues were not present in your case, you're explaining to the judge why your client is sober. So again, used to be in the past that in the actual substantive portion of the manual, you could say, here on page 15 of session 5, here's the list of post-stop clues. You didn't see these in this case. Now you have to actually go into the appendix in order to get that. So, difficulty with motor vehicle controls, exiting the vehicle, fumbling with license and registration, repeating questions or comments, swaying unsteady or balance problems, leaning on the vehicle, slurred speech, slow response to the officer, or providing incorrect information, or changing answers, and then odor of alcohol. You want to be able to say, Officer Jones, you didn't see my client have any difficulty with the motor vehicle controls. Is that correct? But you're trained to look for that. Isn't that right? You didn't see any difficulty with my client exiting the vehicle. Is that correct? But you're trained in your NHTSA training to look for that. Isn't that correct? You want to tie that back during cross-examination to go through and show each clue that is not present. It also identifies excellent and good cues of motorcycle DUI detection. So there in the appendix is basically the visual detection of DWI motorists, as well as the visual detection of DWI motorcyclists. Both of those pamphlets are at the end of session 5. There is a difference between those two lists of visual clues of impairment for motorists and visual clues for motorcyclists. And so I think that the motorcyclist session or appendix pamphlet is the one to really focus on, because I think we generally think about if you do a fair amount of DWI cases, defense, and you're used to the 24 clues of impairment, the list is different for motorcycle than it is for other vehicles. And I think the way that I've argued it in the past is that they are mutually exclusive. And what I mean by that is that somebody that is driving a motorcycle should not be held to the list that is in the DWI detection guide, but that it should just be on the motorcycle detection guide. And the reason that I've argued that is that there are some of the same clues on both lists. So if it was just meant to be, here's the add-on or additional clues that you should be looking for with motorcycles, in addition to the 24 clues, there's no reason to relist any of the original 24 clues. So again, there is a shorter list on the motorcycle DWI detection guide, and it is just worth noting that it is not the same list that is given on regular motorists for the normal 24 clues of impairment for a regular motorist. The next session for officers is phase 2, the personal contact phase. And this is basically kind of the sensual sense observation of the driver. What are my senses telling me about the driver being impaired? So sight is one of the things that is specifically notated on session 6 at page 5 and 6. So you're supposed to be, as the officer, looking for bloodshot eyes, soiled clothing, fumbling fingers, alcohol containers, drugs or drug paraphernalia, bruises, bumps or scratches, and then any unusual actions. So again, you're using this as your cross-examination list. You're trained to look for bloodshot eyes. Isn't that correct, Officer Jones? And you didn't indicate anything about bloodshot eyes in your report. You're indicated to look, you're told in your training to look for soiled clothing. There wasn't anything unusual about my client's clothing in this case. Is that correct? You are trained to look for fumbling fingers. You asked my client for his license and registration. You didn't notate anything unusual about how he passed those to you, about his hands, his fingers, and you're specifically trained to look for that. Is that correct? You didn't note any alcohol containers in the vehicle. Is that right? Now, one thing to be cautious of before you just dive into some sort of standardized cross-examination list is if 3 or 4 of these are present in your particular client's case, this may not be the best cross-examination technique to just run through the list. But typically, if there's only one of these present or none of them are present, you want to specifically walk through each thing that the officer is trained to look for and its absence in the officer's report in this case. Secondly, it talks about hearing. So on pages 6 and 7 of session 6, it trains the officer to look for slurred speech, an admission of drinking, inconsistent responses, unusual statements, abusive language. And so again, you want to walk through that list. You want to go basically say, officer, you're trained to look for slurred speech. You didn't notate anything unusual about my client's speech in this case. You're trained to look for inconsistent responses. That wasn't present in this case. My client was able to communicate with no problems. There wasn't anything unusual about any of the things that he said according to your report. We're always tying this back to the officer's report, right? You get them tied into the NHTSA manual, and then because they're supposed to take field notes and take an accurate or complete an accurate and detailed report, really what happened, if there's no video, what happened on the date of offense isn't as important for court purposes as what was recorded about that. And so it's always a question of, you didn't indicate this anywhere in your report, and you're trained to take, you're asking at the beginning, you're trained to write a full and complete and accurate report. So locking them into the manual, locking them into their report, because it's not that you didn't actually hear slurred speech, it's that you didn't note any slurred speech, which is effectively the same thing, but it is more certain in asking that as a cross-examination question that, in fact, yes, I didn't notate anything about that. Next thing is smell on page 7. So an odor of alcoholic beverages, marijuana, or cover-up odors, or catch-all of anything else that would be unusual. So again, you want to walk through each of those indicators of impairment and show that that was not present in the officer's report with regards to the investigation done on your specific client. Session 6 continued. There's also a overview of divided attention techniques. There are a number of interview and trick questions given to officers in session 6. Officers are also taught the finger count test to have suspects recite portions of the alphabet, but not backwards, and to count backward from one number to another specific number. So see, these are some of the divided attention techniques, not standardized field sobriety tests, but some of the divided attention techniques that are taught in session 6. But it's important to remember this important warning about these divided attention techniques. There are a number of techniques you can use to assess impairment while the driver is still behind the wheel. Most of these techniques apply the concept of divided attention. They require the driver to concentrate on 2 or more things at the same time. They include both questioning techniques and psychological tasks or psychophysical tasks. These techniques are not as reliable as the standardized field sobriety test, but they can still be useful for obtaining evidence of impairment. These techniques do not replace the SFSTs. The emphasis is in the original. So again, this isn't me pointing this out. This is being pointed out to officers in training. So if you have a situation where a trained officer doesn't do any of the field sobriety tests, this point should be hammered, right? It's not a fair investigation if you're not following your training. And it's very clear that whatever techniques you're trained to look for in terms of impairment do not replace the standardized field sobriety tests that are scientifically validated. So the fact that you didn't do those in this case means that you are ignoring the most important part of your DWI investigation. So make sure that you're pointing that out. Session 6 also lists the signs of impairment observed during the license request. And again, you want as many of these lists as you possibly can point to in your cross-examination to show what signs of impairment were not present with your particular client. So forgets to produce multiple documents. If multiple documents are asked for, is a clue that officers are trained to look for. A driver producing the wrong documents, failing to see license or registration in their wallet or wherever they're looking for it in purse. They fumble or drop an item or are unable to retrieve documents. So again, you want to point out you're trained to look for these clues. They weren't present in your report in this case. Is that correct? You want as many of these lists to point out how few of the clues the officer has been trained to identify were actually present when it comes to your client. It also lists signs of impairment observed during the vehicle exit. Shows angry or an unusual reaction, right? So again, that may sound silly, but when somebody is asked to exit the vehicle, you do see that, in some cases of, I can't believe you're asking me to get out of the car, or, slamming the door, whatever it might be. So again, one of the clues of impairment is an angry or unusual reaction. If that's not present in your case, you got to point that out. Cannot follow instructions, cannot open the door, leaves the vehicle in gear, climbs out of the vehicle, leans against the vehicle, keeps hands on the vehicle for balance. One of the things that I think is important, whether you're addressing this in front of a judge or a jury, is that a lot of these lists that we just went through in session 6, also a lot of the clues of impairment, 24 driving clues of impairment, the post-stop clues that were in session 5, a lot of these make it kind of indicate somebody that is really drunk, really impaired, right? So somebody that is dropping things, they can't open the door, right? Like that's how bad the impairment is. They can't open the door, keeping hands on the vehicle for balance. I think what you want to showcase to the jury is that, officers are trained to look for these things to note that somebody is really impaired, right? Like this is a serious sign of impairment. And again, this person that is on video doesn't match up with this plethora of clues. A lot of them, like very much focused on somebody that is hammered, doesn't match up with the way that my client looks on video. So again, I think that being able to showcase that officers are trained to look for some of these clues are signs of impairment. Some of them are signs that somebody is, excuse my French, shit-faced, right? Like, I mean, that's the kind of direction that a lot of these clues look to, is somebody that is really impaired. And so again, contrasting that with your client's lack of impairment can be very helpful in some situations, particularly I would say in front of a jury. Session 7 is the pre-arrest screening. Again, we're going to go through this at lightning speed, super important session when it comes to the 24-hour course. Session 7 gives an overview of the research and clues related to the 3 standardized field sobriety tests. It says a field sobriety test must be one that is reasonably simple for the average person to complete as instructed when sober. Tests that are difficult for a sober subject to perform have little or no evidentiary value. Again, depending on what tests are employed by the officer in your particular case, or if on video, the officer is repeating this like crazy sounding instruction in terms of how to perform a field sobriety test, this may be something to bring out to, again, particularly a judge, but also, or I'm sorry, particularly to a jury, but also maybe to a judge, because it is focusing on the fact that these need to be able to differentiate between a sober and an impaired person. And if they're too difficult for a sober person to do, then there's no reason to believe that they're a good basis for determining somebody's impairment level. This session also gives an overview of the PBT. It indicates the PBT provides direct indication of the BAC level. It does not indicate the level of the subject's impairment. Again, so if you ever have an officer that says, I was basing my arrest on the PBT, again, they're not supposed to do that, right? They're not supposed to be basing it on the specific number. But this also indicates, it doesn't indicate the subject's level of impairment. So it's effectively not helpful in terms of PC if you combined this section of the manual along with the lack of ability to talk about any specific number that is laid out in the North Carolina general statutes. Portable breath test should not be the sole basis for a DWI arrest. It identifies the common factors that can affect portable breath tests. It talks about residual mouth alcohol, breath contaminants, radio frequency interference, and then it emphasizes the importance of doing the SFSTs first and then conducting the portable breath test. So again, use that in a probable cause hearing when you've done the PBT first, when the officer's done the PBT first. They are not supposed to be doing that first. It is against their training, and it talks about how it could basically, create bias in terms of what is being seen on the field sobriety tests. In this session, it also indicates that residual mouth alcohol can take up to 20 minutes to be eliminated in light of potentially having somebody that has recently consumed alcohol. I'm going to kind of jump through this because we're running out of time here. There is a kind of inconsistency between the HGN research and the North Carolina Rule 702. I've laid this out on a couple of the slides within the presentation, but effectively what Rule 702 under the North Carolina Rules of Evidence says is that the officer, when looking at HGN, basically can't testify about any specific number. Can't say the HGN, I saw 4 out of 6 clues. When I see 4 out of 6 clues, that means that there was a 88% likelihood that the person was at a 0.08 or greater. They're not allowed to say that. They're not allowed to reference any specific alcohol concentration. All they can do is say this led me to believe that they were appreciably impaired. There's an inconsistency between what HGN is designed to do and what an officer is allowed to testify about in North Carolina. And so I've had this argument, and I'll just caveat this with limited success in Superior Court when an officer is trying to testify about HGN, because what the officer is allowed to testify under the statute is at odds with what is scientifically the research from HGN. So basically, this is from one of the validation studies that NHTSA did, horizontal gaze nystagmus, the most accurate diagnostic of BAC available to officers in the field. It's the most accurate diagnostic of BAC. HGN's apparent lack of face validity to driving tasks is irrelevant because the objective of the test is to discriminate between drivers above and below the statutory BAC limit, not to measure driving impairment. So again, it's not meant to measure their appreciable impairment. It's meant specifically to test somebody's BAC level. That's what HGN is designed to do. So the fact that in North Carolina, officers are allowed only to testify as to the reverse doesn't make any sense. So I've laid out on this slide those inconsistencies, and I'll just put that out there for note in case you have a case in Superior Court. Coming to the end here, a couple of other points in Session 8. Or Session 8 is Concepts and Principles of the SFSTs. This reviews the Colorado, Florida, and San Diego field studies, these are extremely outdated. I mean, these are outdated studies, but it goes through those. It goes over the categories of nystagmus, and it talks about medical impairment. So we won't get too deep into session 8, but again, this is one of the things that is most important when it comes to the 24-hour class, if you're able to get into that. So highlights of the remaining sessions. Just going to pull out some of these at random. On session 10, page 3, it is highly recommended by NHTSA that officers utilize an SFST log, and that is basically a catalog of all the DWI investigations that they've done, and there is a sample log in there. Most officers that I have dealt with do not keep a log. So again, just one more way that they're not following their training. It is essential officers develop the ability to write a clear, complete, and concise report describing their observations and results. It is essential the report clearly, completely, and accurately describe the total sequence of events from the point the driver was first observed through the arrest, the chemical test, and the subsequent release or incarceration. So again, detailed reports. You're trained to conduct detailed investigations and to complete thorough reports. You just want to emphasize that. Deviation on SFSTs and the importance of standardization is at the bottom of page 27. So you want to kind of know kind of the no-nos of deviating from standardized field sobriety techniques, because that is pointed out. This one is always good if you ever have an officer that does a live demonstration, and obviously it may not be in your best interest to embarrass an officer, but in there, in session 11, it says, be certain that you can do in court all the tests you ask the defendant to perform at the time of the arrest. If you cannot do them, the jury will not expect the defendant could have done them properly. And I have seen many a time where an officer was asked to demonstrate a field sobriety test and either tripped or had to use their arms for balance or, was swaying, whatever it might be, something that just doesn't look good in the courtroom. So again, that's one of the indications in training. Finally, at the end of this is not one of the 15 sessions, but it's kind of on the back end of the participant manual, is the introduction to drugged driving. And this is not required to be presented in the 24-hour class, but a lot of the 24-hour programs do touch on this kind of add-on session. One thing of note to point out whenever you have a case that involves a drug-impaired driving situation is that even in their notes, again, they were instructed to read the manual, right? They're instructed to read the manual. This is part of the participant manual. It says wherever possible, a local DRE should be summoned to assist with the investigation. That's at page 30 of the drug impaired driving section, whenever there is a non-alcohol anticipated DWI investigation going on. So officers are trained to get a DRE involved. You can ask, why didn't you do that? In this case, didn't your training indicate that you should request a DRE? One thing that I learned from Marco Aureliano a few months back is that there is or at least there was at the time that he was a DRE, a statewide kind of DRE pager system that allowed for any officer to basically contact for a DRE, and a statewide page would be sent out to every single DRE officer. They could respond. They could offer advice telephonically. If they were closer in the area, they could go participate in the investigation. So again, I think a lot of officers will say, well, there's no DRE available, or we didn't have one, or we don't have one within our department, and may not be aware that there are options in terms of contacting a DRE, which again makes the lack of reach out a little bit more helpful when it comes to your cross-examination. So Uh, I just wanted to quickly highlight we have a CLE coming up in March at Campbell Law School. It is in one of their beautiful courtrooms, attacking speed in a DWI case. We are going to work through basically the officer manual in being trained for time distance measurement and utilizing radar devices. Doug Scott is going to be walking us through that and then also conducting some sample mock cross examinations of officers. Since this is one of the most common reasons for a stop in a DWI case, if there's a way to attack the speed itself, that is obviously a great way to kick your case off. So we'll be doing that here in a couple months. Please feel free to call me at any time on my cell phone, which is what's listed up here. Email me. I love talking about this stuff. I have a podcast specifically on DWI related topics. And if you're interested in coming on, I'm always looking for guests. So I think that is all that I have. I definitely have time for any questions, but also realize that we are at the hour here. So I'll go ahead and stop my screen share, and then yeah, if there's any questions, I'm happy to answer those.